the person who has been arrested now could be a state witness, could turn to be a state witness. We still don't know, because the fact that you give money to somebody who intends to bribe you, automatically you become part of the corrupt system. The system that is trying to play about with corruption, you get entangled. So the personnel, by the virtue of the fact that he gave money to these people, could also imply that giving that money, he becomes accomplice. But this is now subject to investigation. The investigation that is currently taking place will either exonerate the personnel of Dokolo or implicate him. So far, we cannot take chances. He gave money, he's in our custody. Those who received money are in our custody, subject to investigation. They are all suspects at the moment, but they'll be investigated.
My name is Assistant Superintendent of Police, Patrick Jimmy Okema. I'm newly posted in North Kyoga as the Regional Public Relations Officer. First and foremost, I would like to confirm the arrest of the people who are involved in a case of conning within Lira. And as I can share with you now, the case is impersonation and obtaining money by false pretense. These are two people who approached the principal personnel of Dokolo District Local Government and asked him for 2 million, from him, and already 400,000 was dispatched to them. But late, I think the personnel had a contact with one of the colleagues at Lira, who went ahead and mobilized some people, and they were picked from Lira hotel. We have done all it takes. Statements were recorded. This arrest was effected on the 10th, and the complainant made his statement, or Tim Moses made his statement the following day, and yesterday, on guidance from the anti-corruption unit in State House, guided us to equally arrest him. We did that, but this morning the file has been sent to Resident Chief State Attorney, who has already sanctioned the file, and two suspects are the ones going to be arraigned in court. That is Apeny, Elly, and Olwa, Denis. The Otim Moses has been exonerated as per the guidance from the Resident Chief State Attorney. So we are making efforts now to get their fingerprints so that they are arraigned before court this afternoon. I thank you.
Count one, the statement of offense that is the impersonation under section 381 of the Penal Code Act, Cap 120. The particulars of offense that Elly and Olwa, Denis, on the 10th day of May 2021 at Lira Hotel in Lira City with intent to defraud Team Moses, civil servant, stroke personnel officer with the district local government, falsely pretended, falsely represented yourselves as State House attached, State House Anti-Corruption Unit and obtained 500 Uganda shillings from the state of Team Moses. This Apeny Elly, the other side of the church. Is it true? You are going to be tilted. Denis, the other side of the church. Right. Is it true? You are going to be tilted. Count two, statement of offense, uttering a false judgment, contract section 351 of the Penal Code Act, Cap 120. The particulars of the offense are that you, Apeny Elly, and Olwa Denis, on the 10th day of May 2021, at the Lira Hotel in Lira City, knowingly and fraudulently uttered a false judgment to obtain Moses with a letter addressed the State House Anti-Corruption Unit, Kampala, Road 6, Upper Kororo, purporting to have originated from Jokolo, District Local Government. Elly, do you understand the church? Is it true? You will not give the return. Denis, you understand the church?
You understand the sign to immigration. I would understand and I pended my signature. That is immigration.
But do you understand what I've read to you?
Yeah, but it is not.
Can you do that? Count three. Obtaining money by false pretense, contract section 305 of the Penal Code Act. Such as the offense that is alleged that you are Apeny Elly and Olwa Denis on the 10th day of May 2021 at Lira Hotel in Lira City with the intent to defraud. We both obtained 500,000 Uganda shillings from the Team Moses by force of pretending that it was to rescue him from being arrested by the State House Anti-Corruption Unit. So if you understand the church, is that true? Denis, we have not been to that. Inquiry is true.
Should be clear information and
What is the conflict?
I'm not in personal conduct with this case. I'm afraid national information in Germany.
this court. Your Honor, I have heard. Your Honor, I do appear for the accused person. I do have instruction in motion to pray for on behalf of the accused person. For the following reasons, Your Honor.
Okay, I said you have no questions. Who has any questions? Who has instructions? Please state.
As I've earlier on said, I'm not in final conduct in this case. My role ends in the pray for mention. And the person in personal conduct will come and take over from there.
We shall, I don't know, we shall start it over to Michael.
I don't know. Maybe I wanted to give my reasons first, but when a state says he does not have personal conduct, the accused person will be produced for this matter in court. And the presumption is that execution is ready. The matter to be had. That's the presumption under the law. Now, this court, Your Worship, cannot be misled to believe that accused person should be produced in court. Then they are right to pray for bail, not hard because state now purports, runs away from the case that, now you see, I am not in personal conduct. In fact, such situations, Your Worship, such cases have had to be dismissed once state appears not ready in the first place. When they are ready, they now come fully ready. And being ready is coming to court.
Council, I think, rather than urging this, you can make your whatever your prayers.
Most of them. Usually my prayers are, I sympathize with state. Probably he has other instructions. But let him also tell court whether or not the person in personal conduct, is he there now, today? How long does this court need to give him? So that court can hear us in our prayer.
We pray that you proceed to your application.
That's correct, Your Worship. But the simple reason, maybe let me conclude then you make a return. But the simple reason is that the accused person has been on police custody since the 10th. That was, I think, Sunday.
I think let's wait this first.
Council is very knowledgeable in what takes place in court. And if I'm not in personal conduct, I cannot force myself to entertain the bail. Okay, he can apply, then we pray for date to reply. There's nothing wrong with that. So we pray for 1 week here also. You can give us next week, any day next week.
We can make this
You can make these applications, then it is adjourned for reply.
Possible, Your Honor. Let me proceed to make an application.
I make a ruling on that.
Oh, yes, Your Worship, we felt the ruling agreement that whether or not state can actually support what to be ready to proceed, having presented the accused person. Yes, Isaac Okay are my names, and I am an advocate representing the accused person, Olwa and Apeny. The case is really a simple case. You know, it's a simple bailable case. Unfortunately for the accused persons, their right seems to be abused because they were arrested on Sunday,
and then they produce them on Friday, well knowing that probably court may not even sit. Now, even the prosecution or the prosecutor or the state attorney who comes purports not to be having personal conduct. This is a proper case of persecution, not even prosecution. So we believe that court, as a center of justice, should be able to understand and read such cases. Just because they attract public attention, an accused person has a right, and once court has the powers to grant the powers under the law to grant bail, they should proceed to grant, not just to listen to flimsy reasons, especially when it has been brought to the attention of court that the accused persons have been in custody for more than the required 72 hours. Well, we leave it to court. We know that maybe now that they have been remanded, we believe that on Tuesday we are going to have these other reasons again. Otherwise, it brings so many questions about what justice exactly is. Justice must be done irrespective of phone calls, because the law is the law, and everybody is below the law or must respect the law. Yes.
Could you remind us the charges?
Yes, they are charged with impersonation. Okay. They are also charged with uttering false document and receiving money by false pretense. Very simple charges, very, very simple and negligible charges, which should not be attracting, powers from I don't know which other side, by trying to even make prosecution fail to proceed. That's a charge that this prosecutor in court can proceed, not to wait for the resident state attorney to come and proceed in a small matter like that. It's
what exactly do you
pathetic.
mean by not being in personal contact?
It all goes back to what I was telling you earlier on, that you already see cases of persecution. Accused persons are supposed to be prosecuted, but not persecuted, because this file was sanctioned and they were produced today in court. They knew that the accused person have a right to bail. Unfortunately for them, they now run away from that so that the accused persons can be remanded, which is unfortunate. But we shall follow it up on Tuesday and ensure that the accused persons are granted there. It means in our processes of handling these matters, there is, personal contact means that attorney, handling that file. Some of the facts may be within his knowledge only and not within the knowledge of another attorney who comes. So mostly lawyers tend to, when they are running away from handling a matter, that's what they do. And courts in higher jurisdiction do not take that lightly. By the time you appear in court, the instructions given to you must be that you have instructions to proceed, especially when it comes to prosecution. So you don't come and say, I have personal contact, that I don't have personal contact, yet you are the prosecutor in that court. It's very unfortunate.